Hello, welcome back. We're talking about the presidency today and how the president fits into the constitutional structure of our government. The media calls the president many times the most powerful person in the world. This series of lectures, first with Alexander Hamilton and then with Abraham Lincoln, and later on some other political science perspectives, will show that the president really isn't in the position to command anyone or anything except as the role of commander in chief when he becomes the ultimate authority in military affairs. But the presidents the presidents of the past and the presidents in the future have to understand that their role really is one of persuasion. And this is by design. We begin with Alexander Hamilton's essay again in the Federalist Papers, talking about the presidency and the creating an executive. And again, many of the revolutionary founding fathers were against and were afraid of a tyranny. And many of them, like Patrick Henry, argued that why would we fight the revolution just to have a president? Instead, sounds like he's a king. And so Hamilton takes this argument head on, and he compares it with two different executives that his generation was familiar with. The King of England, of course, and the Governor of New York. Now again, as I've mentioned before, remember that Hamilton is addressing the citizens of New York because he would like them to vote in favor of ratification of the Constitution. So again, this is essay number 55 on page 308 in your text, and Alexander Hamilton, Federalist 69. One of the things I really like about the way Hamilton writes and the way he articulates his arguments is he comes right to the meat of the matter. And he starts with, again, he knows what the debate's about. He knows why people are afraid to have this new office of the presidency. And so he says in the first beginning of the first full paragraph in the essay, the first thing which strikes our attention is that the executive authority, with few exceptions, is to be vested in a single magistrate. This will scarcely, however, be considered as a point upon which any comparison can be grounded. For if in this particular there is a resemblance to the King of Great Britain, there is not less a resemblance of the Grand Seigneur and the Khan of Tartary, to the Man of the Seven Mountains, or to the Governor of New York. So what he's saying in the first full paragraph of the essay is, yes, there's going to be one person. One person is going to hold this office. Now, again, the founding fathers had the experience of Rome in their minds. They also had this long war, this long, costly war to get rid of a king. And so one can understand how they would be very, very hesitant to have this idea of one person in the executive to represent all of the states. Hamilton comes right out and says, yes, right? He gives his critics that point. Yes, there's going to be one person. Then he starts talking about and using the Article 2 of the Constitution, which spells out the presidency, the specifics of the office in the language of the Constitution. Again, this is his section of his argument that is evidentiary. That this magistrate is to be elected for 4 years and is also to be re-eligible as often as the people of the United States shall think him worthy of their confidence. Of course, this has changed. This has changed because after Franklin Delano Roosevelt, we amended the Constitution so the president can only run for 2 terms. In these circumstances, there's a total dissimilitude between him and the King of Great Britain, who is an hereditary monarch possessing the crown as patrimony, discernible to his heirs forever. But there is a close analogy between him and the Governor of New York, who is elected for 3 years and is re-eligible without limitation or intermission. If we consider how much less time would be requisite for establishing a dangerous influence in a single state than for establishing a like influence throughout the United States, we must conclude that a duration of 4 years for the Chief Magistrate of the Union is a degree of permanency far less to be dreaded than that office than a duration of 3 years for a corresponding office in a single state. So again, what is Hamilton doing? Hamilton takes this idea of one person and a 4-year term. And he's saying to them, he's saying to the people of New York, there's nothing to worry about here. There's nothing to worry about here because you've been living under a governor who was elected for 3 years. The New York governor is elected for 3 years, and he's only in charge of one state. Don't you think it's easier to do mischief? Don't you think it's easier to create a dictatorship in one state in 3 years than at this time a 4-year term in 13 states? And you see again, what is the rhetorical tool that Hamilton is using? He's using this idea of similarity, right? He is bringing and introducing something that is similar to his audience and compare and contrast. To the thing that is new, right? To the new. And so again, he is dealing with a government, a document, a constitution that is not in existence. And people have fears, and these fears are reasonable. These fears are very reasonable, especially when we take into the account of how the government is structured. The president was not designed to be a king. The president was not designed to be all-powerful. The presidency was not designed to have the person hold that office thought of as the most powerful person in the world. Now, again, we go into very familiar territory for this administration when he talks about impeachment. The President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes or misdemeanors, removed from office, and would afterwards be liable to the prosecution and the punishment in the ordinary course of law. The person of the King of Great Britain is sacred and inviolable. There is no constitutional tribunal to which he is amenable, no punishment to which he can be subjected without involving a crisis of national revolution. In this delicate and important circumstance of personal responsibility, the President of a Confederated America would stand upon no better ground than the Governor of New York, and upon worse ground than the governors of Maryland and Delaware. So again, he is comparing the role of governor in the state to the presidency. But this is going to be one of the themes that carry out through our discussion, is this idea of the rule of law. And some of you may have read ahead, some of you may have talked and examined the last essay in this unit called Executive Privilege, and it was how the Supreme Court dealt with Richard Nixon and his argument about executive privilege. The point is that throughout this theme, throughout this unit, there will be this idea of no one is above nor below the law. And the president, for sure, is not above the law. Neither fear nor favor, right? The president also, if he is impeached, should have the due process and the presumption of innocence that all of us share under the constitutional system. But, as we've talked about in a great deal about impeachment, once the president is impeached, and once the Senate votes as a jury to convict the president's out of office. That's all. The president's gone. The president later on, though, is subjected to rule of law. And if he is convicted or she is convicted after leaving office, If that person is convicted, they will suffer the punishments as would any other person in this country. So again, comparing it to the governors and the King of England. He goes on, the President of the United States is to have power to return a bill which shall have passed the two branches of the legislature for reconsideration, and the bill so returned is to become a law, if upon reconsideration it is approved by 2/3 of both houses. Again, this language should be very, very familiar with you by now. Why? It's in the Constitution. That's Article 1, Section 7, how a bill becomes a law. The President does not determine what the law is. Congress does. The President has a role, and he has a veto. But that veto can be overridden. Again, comparing it to Great Britain. The King of Great Britain, on his part, has an absolute negative upon the acts of the two houses of the Parliament. The disuse of that power for a considerable time past does not affect the reality of its existence, and it is to be ascribed wholly to the Crown having found the means of substituting influence to authority, or in the art of gaining a majority in one or the other of two houses, to the necessity of exerting a prerogative which could seldom be exerted without hazarding some degree of national agitation. The qualified negative of the President differs widely from this absolute negative of the British sovereign. The President does have a veto. The President has a veto, but if he cannot convince 2/3 of the Congress to agree with him, that bill will still become a law. Under the British system, if the king is against it, that's it. The king is against it. So Hamilton brings up this other, pretty interesting point that if you have rule of law, then procedures must be followed by everyone. If you have the divine right of kings, God told me. It's my right to be, I'm a king. That's what I can do. That's, again, this difference between ruled by men and rule of law. And of course, I mean men as a collective. He goes on and talks about, as I said earlier, the President as Commander-in-Chief. The President is to be the Commander-in-Chief of the Army, Navy of the United States and of the militia of the several states when called into the actual service of the United States. He is to have the power to grant reprieves and pardons for offenses against the United States, except in the cases of impeachment. And again, as we talk in current events today, President Trump has commuted a sentence of one of his allies, and there's a whole question about, does the president have this absolute power of pardons? And of course, the Constitution does not limit it at all. And people who disagree on the politics of this are starting to talk in terms of limiting this power. Well, there's always talk about this kind of thing. But again, President Trump, according to the statistics, has granted less pardons than either Clinton or Bush or Obama. Now, who knows, right? Who knows what's going to happen in the election, and who knows what's going to happen whether or not President Trump loses that election. But what happens most of the time is a day or two before a lame duck president, a president who has lost the election, or a president who is leaving office, what they tend to do is pardon a ton of people. George H. Bush pardoned all of the people that were involved in Iran-Contra. You had, of course, the famous Gerald Ford pardon. But again, do you need an executive to have the authority to, in the case of a person, to override the judicial system? Do you want to have that? Well, I think all of us would agree that it should be used sparingly and it should be used with great caution. President Clinton made a ton of pardons and notorious pardons, which probably hurt his reputation on his way out of the presidency. So these ideas of pardoning and limiting the power of pardon is something that right now, as the Constitution says, the Supreme Court would probably reject a congressional action on that issue. The president is commander-in-chief. Again, remember, there was no standing American army at the time. You had a collection of militia. And when there was a national emergency, the governors would call the militia up, and then the president would be commander-in-chief. And Hamilton is going to go on and talk about this, why in actuality, when we're dealing with military power and we're dealing with the power to have a coup d'etat is a French term that means the military takes over the government. In shorthand, it's called the coup, right? But coup d'etat. And again, forgive my pronunciation. And it's probably spelled wrong too, since I don't speak French. But again, founding fathers are very, very concerned about a coup d'etat. This is why they were very, very smart in making the president the commander-in-chief, so the military chain of command goes through the presidency. Now remember, also, every officer and every soldier and every person who's in the government has made an oath to defend the Constitution. So they have to follow the orders, the military orders of the President of the United States, or resign. And you have seen, again, in this administration, you have seen certain defense officials and certain state officials, Department of State officials, resign because they would not do what was asked of them. That's not a comment either on was it appropriate or not. It's just that was this effect. So then he says, in the most of these particulars, the power of the president will resemble equally that of the King of Great Britain and of the Governor of New York. The most material points of difference are these. And then again, when you're writing an essay, think in terms of how to be obvious to your reader. First, the president will have only the occasional command of such parts of the militia of the nation as by legislative provision may be called into the actual service of the Union. The King of Great Britain and the Governor of New York have at all times the entire command of all of the militia, and again, today's militia is the National Guard, all of the militia within their several jurisdictions. In this article, therefore, the power of the president would be inferior to that of either the monarch or the governor. And again, one could argue, and we are in the middle of this COVID-19 pandemic, that President Trump is relying on governors and local mayors and local officials to ask the federal troops, the federal resources to come into their state. I said one could speculate that. I'm, again, not inside that, so I wouldn't know as a matter of fact. But the tradition is that when you have, for example, when we had the LA riots in the 1990s, the tradition is the governor and the mayor ask the federal troops to come. Secondly, the president is to be the commander-in-chief of the Army and the Navy of the United States. In this respect, his authority would be nominally the same as that of the King of Great Britain, but in substance, it's much inferior to that. Thirdly, the power of the president in the respect to pardons would extend to all cases except those of impeachment. I heard on the news this morning that people are worried about the president pardoning himself on the days, if he loses election, on the days leaving office. Well, that's patently ridiculous, right? Because the language of the Constitution says that the president cannot interfere in impeachment cases. And this president has been impeached. He wasn't convicted, but he has been impeached. Did he pardon anybody about that? No, not to my knowledge. He has not. Will he? I don't know. He might. But it is in his purview, it is in his power to do so. And again, Hamilton agrees with me, and Hamilton agrees with the argument. The better to judge of this matter, it will be necessary to recollect that by the proposed Constitution, the offense of treason is limited to levying war upon the United States and adhering to their enemies and giving them aid and comfort. And that by the law of New York, it is confined within the similar bounds. Right? So again, why is the crime of treason so difficult to prove in the United States? Because the founding fathers were all traitors, right? The founding fathers were all treasonous to the King of England. And so it was a pretty sensitive point that the founding fathers got around and said, well, there's a reason why we did it, right? The Declaration of Independence, there's a reason why. There's a rationale behind it. So they made it difficult. You need to have two witnesses to convict someone of treason, and treason is defined in the supreme law of the land. Fourthly, the president can only adjourn in the national legislature in the single case of disagreement about the time of the adjournment. The British monarch may prorogue and even dissolve the parliament. The governor of New York may also prorogue the legislature of this state for a limited time, a power which in certain situations may be employed to a very important purpose. All right, that means to adjourn the legislature. The president is to have the power with the advice and consent of the Senate to make treaties provided 2/3 of the senators present concur. The King of Great Britain is the sole and absolute representative of the nation in all of foreign transactions. He can, of his own accord, make treaties of peace, commerce, alliance of every other description. It has been insinuated that his authority in this respect is not conclusive, and that his conventions with foreign powers are subject to the revision and stand in need of the ratification of the Parliament. But I believe this doctrine was never heard of, and until it was broached upon the present occasion, every jurist of that kingdom and every other man acquainted with its constitution knows, as it has established fact, that the prerogative to making executive treaties exists in the crown in its utmost plenitude, and that the compacts entered into by the royal authority have the most legal validity and perfection, independent of any other sanction. The Parliament, it is true, is sometimes seen employing itself in altering the existing laws to conform them to the stipulations in a new treaty, and this may have possibly given birth to the imagination that it is a cooperation with necessary to the obligatory efficacy of the treaty. But this parliamentary interposition proceeds from a different cause, from the necessity of adjusting a most artificial and intricate system of revenue and the commercial laws to the changes made in them by the operation of the treaty, and of adopting new provisions and the precautions to the new state of things to keep the machine from running into disorder. In this respect, therefore, there is no comparison between the intended power of the president and the actual power of the British sovereign. The one can perform alone what the other can do only with the concurrence of a branch of the legislature. It must be admitted that, in this instance, the power of the federal executive would exceed any of that of the state executive. But this arises naturally from the sovereign power which relates to its treaties. If the Confederacy were to be dissolved, it would become a question whether the executive of the several states were not solely invested with that delicate and important prerogative. What he's saying in that is that, of course, if we don't have this Constitution and the Confederacy is dissolved, then the governors, of course, would have this power to make treaties. Let me again, talk in terms of the constitutional structure that we're dealing with. The founding fathers gave Congress the power to make war, right? Congress has the power to declare war. And the Senate has the power to ratify treaties. Why? Because the founding fathers were very afraid of one person making these decisions. They were very concerned about this idea of one person, as the King of England could do, bring a nation into war. What didn't the founding fathers anticipate? The founding fathers did not anticipate Congress not using its power. Congress has not declared war since World War II. Why? Because Congress people do not want to have that responsibility. want to sit on the sidelines and they want to criticize if it goes bad or be part of the winning team if it goes well. The same is true with treaties. You hear people talk about globalization and trade treaties. Well, in 2016, if one remembers, both major candidates from the Democratic Party and the Republican Party were against free trade treaties. But the Senate keeps on voting for these things. Why? Because again, they're taking and they're giving their power of consent to the executive branch. I don't think the founding fathers really understood that Congress would do that. It makes really, from an outsider's point of view, it makes very little sense, except in the political view. That's how you get reelected. You get reelected by never having taken a position that actually would hurt you. The president is authorized to receive ambassadors and other public ministers. This, though it has been a rich theme of declamation, is more of a matter of dignity than authority. It is a circumstance in which, without consequence, the administration of the government, and is far more convenient that it would be arranged in this manner. That there should be a necessity of convening the legislature or of its branches upon every arrival of a foreign minister, through it were merely to take the place of a departed predecessor, would be inconvenient. The president is to nominate, and with the advice and consent of the Senate, to appoint ambassadors and other public ministers, judges in the Supreme Court, and in general all officers of the United States established by law and whose appointment are not otherwise provided by the Constitution. Hence it appears that except for the concurrent authority of the president in the article of treaties, it would be difficult to determine whether that magistrate would be in aggregate possess more or less power than the governor of New York. And it appears yet more unequivocally that there is no pretense for the parallel, which has been attempted between him and the King of Great Britain. But to render the contrast in this respect still more striking, it may be used to throw the principal circumstances of the dissimilitude into a closer group. The President of the United States would be an officer elected by the people for 4 years. The King of Great Britain is a perpetual and hereditary prince. The one would be amenable to personal punishment and disgrace. The person of the other is sacred and inviolable. Right? So again, he's going back to this idea of Republican form of government. And this is, again, one of the things that I really don't understand in our time is if you don't like who's president, defeat the person at the elections. Defeat the person. You don't have to change the system. You don't have to change the Constitution. You beat the person. Knock on doors. Get people to vote. And win the Electoral College. I know many of you are probably saying, well, wait, he didn't get the majority of the vote. Doesn't matter, as we talked about before. So again, the president, that office is open every 4 years. The person can run twice. Defeat him. You hate him, defeat him. Work on it. But see, the problem is people don't understand this. Or they don't want to do it. Because getting people to vote is much harder work than protesting. Much harder work. The King of England, can't get rid of. Look at the Queen. Queen of England's been on the throne for what, 90 years? Pretty close. So, I mean, she was queen when Churchill was prime minister in the 1950s. And that's all Hamilton's saying, right? Hamilton's saying, look, if the person who is president is the worst ever, impeach them. And people tried to impeach this president. They couldn't convict him. So now, defeat him. Then that might happen, who knows? And if it does, great. If it doesn't, great. I'm not here to talk about that. What I'm here to talk about is the constitutional structure of the presidency. And I hope you can see that the powers of the president compared to the governor of New York or the King of England is not that powerful. He ends this essay, right, with this idea that we are a secular government, separation of church and state. He's talking about how the King of England is head of a church. And he goes on, the one has a particular spiritual jurisdiction. The other is the supreme head and governor of the national church. What answer shall we give to those who would persuade us that things so unlike resemble each other? The same that ought to be given to those who tell us that a government, the whole power of which would be in the hands of an elected and periodical servant of the people, is an aristocracy, a monarch, and despotism. Right? So again, Hamilton is talking in terms of this idea of the restrictions on the presidency by the Constitution. Now again, we are going back and we can talk about our current situation. We can talk about the current times where is it the president's fault if Congress abdicates its responsibility? And again, I'm talking in terms not just this president, I'm talking in terms of since the Korean War, declaration of war absences, immigration, right? We know, because we read the Constitution, we know that the president is a minor player in this idea of who is an American and who is in this country, if Congress wants to take that on. And again, right, what have we seen? We have seen that Congress does not want to take this on. They don't want to take the responsibility of getting 2/3 members and passing immigration reform. They rather have it on, again, both parties rather have this as a political football. So Hamilton is telling us in his argument of why you want to have a ratification of this Constitution, he is telling us that the president is not a despot. He's telling us that the president has less power than the King of England. And he's correct. But the problem is, and we know this with our discussion earlier in this class on the Supreme Court, the problem is the Supreme Court is not going to tell somebody, right? It's not going to tell Congress, hey, you should be doing that. What happens? How does the Supreme Court decide and interpret the Constitution? There has to be a case. The members of Congress, because we keep on reelecting them, again in the essay, popular Congress, unpopular Congress people. Pardon me, I got that mixed up. Popular Congress person, unpopular Congress, right? We know that we keep on reelecting these people and they're getting rewarded for not taking a stand. They're getting rewarded for not voting. They're getting rewarded for not solving these problems. Again, this is both parties. This is not the Democrats and the Republicans. This is both parties. Go again, if you want to review the constitutional structure of Congress and their powers, go again and read Article 1, Section 8. And the problems that we have, the problems that you see, they could be solved by Congress, but Congress doesn't want to. And Hamilton points this out, right? Hamilton's saying you have nothing to worry about. If you're worried about a Caesar or a dictator, you have nothing to worry about in this Constitution because the presidency isn't the most powerful office in the world. The King of Great Britain has much more power, plus the governor of New York has much power. And so what happens is Hamilton convinces, with his essays, the Federalist Papers, they convince the New York voter to ratify the Constitution, and the Constitution becomes law, and the presidency and the people who hold that office from 1789 to today are under the law. And that is the big difference between any other leader outside of the Western civilization, outside Western Europe, the United States, and some of the democratic republics in both Latin America and in Asia. But you have the president of Russia, and I use the term president very loosely. What guy just got another, he's president for life. That's an oxymoron. Or the president of China, who it's a dictatorship. These people are not presidents. They're dictators. And so this is the main difference. Again, going back to the three pillars of what makes the American nation. Popular sovereignty. People vote, right, for representatives. Those representatives then vote for the president. In this instance, it's the Electoral College. Rule of law. The president and everyone else is under the rule of law without fear nor favor. And finally, tolerance. Those are the three things that make us Americans. And we've talked about that in great extent. But those things also apply to who lives in the White House and who is working in the Oval Office. In the next video, we'll be discussing, in my view, the greatest president ever, Abraham Lincoln, and we'll be discussing this idea between the person and the moral perspective of the person and the law, and how all of us are under this duality, not just presidents. Until that time, stay safe.